Hi there. How y'all doing? Welcome to Defense Tires. I'm your host, Bob Mata, and Allie should be joining me in the very near future. What is up, y'all? Happy afternoon, happy evening, depending on where you're at. This is going to be an interesting live. We're going to be covering what I feel is an important case for a lot of different reasons. As you guys know, I am a staunch supporter of the U.S. Constitution. I am a staunch supporter of our rights in this country. And the case that we're going to be looking at today is a very, very interesting case in terms of the First Amendment and how it fits in, especially when it comes to reporters, journalists, YouTubers, whoever, whatever you want to call people that are reporting on everything that's going on in the world today. And it is Slippin' Pete. Todd Mullis ain't going anywhere. Todd Mullis, we can catch up, dude. It's going to take a long time for them to come to an answer on that. I promise I'll get to Mullis. I have not abandoned Mullis. It was much shorter than they said it was going to be, which made me very happy. We're talking 10 days on Mullis, but it ended up ending on Monday. So we'll definitely get to it. There's only 3 days of hearings we got to get through over there. But I promise, for those of you checking that Mullis thing out with us, we have not abandoned it. We have definitely not abandoned it. But back to the topic in which this live is actually about, which is the current case of the Commonwealth of Massachusetts versus Aiden Kearney, AKA Turtleboy. If you don't know who he is, I've always called him a Gonzo journalist. He's, love him or hate him, you cannot argue with the fact that he really put Karen Reed on the map. You may not want to hear that, but there's no other way to look at it. I mean, nobody was really talking about that case. The motion to dismiss had been filed by the defense. It wasn't getting any kind of publicity. And Aiden found it and started digging in on it. And he absolutely blew this case up to what it is. So, whether you're a fan of his technique and style is a completely different issue. In terms of what we're doing here today, you really kind of have to set that aside when determining whether or not his speech was protected in terms of the way that he operates, in terms of his investigative reporting. It's a really interesting case. And somebody linked me in on Twitter to the hearing that took place yesterday, right after. It was actually happening simultaneous to Karen Reed's hearing. I had really wanted to see that hearing, so I'm glad that I think it was Kaylee hit me with that link. So thank you for that, Kaylee. I appreciate not having to dig around for it. So what the plan here today is, I want to watch that hearing. But before we dig into it, I think it's important to understand kind of the the primary thrust of what he's been charged with, the bulk of the charges are pursuant to this statute in Massachusetts regarding intimidation to a witness. And as far as I know, they've hit him with 8 counts. I was digging around trying to find out where I could get my hands on the charging papers, and I could not dig them up anywhere. It was weird. Tracy tried, and usually if they exist, she can find them. And she didn't really have any luck with that either. So I don't know what the deal is with that. I don't know why I wasn't able to find those. Yeah, I have read the Federal letters. Those made sense in a lot of different ways. And when we get to the pleading, so what we're going to do is we're going to kind of go through the statute in which he's been charged, primarily with the felony counts, which is what obviously everybody would be concerned with if you're being charged with anything. Not that misdemeanors aren't nothing, but in comparison to felonies, it's a big difference in terms of kind of life altering if you get convicted on felonies as opposed to misdemeanors. So we'll check out the statute, try to get an understanding of what the statute is, what it calls for, and what you need to have done in order to be found guilty under that statute. But that's where it gets interesting, because when you read the statutes on their face, you're gonna be like, oh, well, it seems like he may have done these things with these witnesses. And I'm just gonna say flat out, I've never seen a statute like this ever. It's a scary statute in a lot of different ways. And then what we're going to do is we're going to dig into the defense's motion to dismiss. Bradel and Betterow prepared it. I don't know who did the bulk of the writing. It's well written. It's a well drafted motion. It gets into the issue at hand, which is whether or not the things that Aiden said and did were protected by the First Amendment, free speech, and how that interplays with the fact that he's a journalist. And I really enjoyed this hearing. I watched it yesterday, or as soon as I got the link. I guess it was this morning. I watched the whole thing. It's not very lengthy, about 35 minutes, and it's a real back and forth between the judge asking questions, kind of challenging each of the lawyers, both from the Commonwealth and Bradel, who is Aiden Kearney's attorney. And it's kind of a back and forth. It's got a real appellate court type feel to it, as opposed to just a lawyer kind of up there, arguing for a half an hour or longer. It's really, the judge has questions, inquiries, and then he wants the attorneys to respond to his questions. So I found it very interesting. And I think this is an important case for a lot of reasons. And first and foremost, because free speech, I mean, it's the First Amendment for a reason. It's the bedrock of our society. We have to be able to speak our mind. Obviously, there's some carved out exceptions, but for the most part, you can say whatever you want. And, in situations where people may not like it, or you've hurt someone's feelings, or you've insulted someone, or you've defamed them, there's remedies for that, but it's not in the criminal court. That's in the civil court. And the problem here is that they've appeared to weaponize this statute and are using it as a full frontal attack on the First Amendment. So, all right, I'm going to pull up the statute because I want you guys to understand what the statute says exactly. We're going to do this like we're lawyers instead of screaming at each other on Twitter. How about that? You guys like that? I like that. All right. So it's 13B, and this is under Chapter 268, and these are from the Commonwealth of Massachusetts. This is their criminal statutes. Okay. So first of all, 13B, it's going to define a couple things first. It's going to define an investigator, and it's also going to define the term harass. What does that mean? And you like those kind of things. You like definitions leading into a statute because, as I say all the time, words matter in the law. They just do. They're critical. As a matter of fact, I don't know that there's anything more important than words when it comes to the law. And how things are interpreted is really the heart of the legal profession. Interpretation is everything. That's why you have two sides. People can interpret the law differently. People can interpret facts differently. People can interpret evidence differently. All of those things must be taken into account. So it helps to have the legislature write up in the context of a statute what a word means, because what it may say in Black's Law Dictionary or Merriam-Webster may not be exactly how it is to be applied in a statute. So that's why it's always helpful when the legislature writes up a new law and it makes it all the way through and gets signed into law, that they explain, all right, well, this is what we mean by harass. Okay. So an investigator is an individual or a group of individuals lawfully authorized by a department or agency of the federal government or any political subdivision thereof, or a department or agency of the Commonwealth or any political subdivision thereof, to conduct or engage in an investigation of, prosecution for, or defense of a violation of the laws of the United States or of the Commonwealth in the course of such individuals or groups' official duties. So that's the definition of investigator. So the definition of harass, as it applies to the statute, is to engage in an act directed at a specific person or a group of persons that seriously alarms or annoys such person or group of persons, and would cause a reasonable person or group of persons to suffer substantial emotional distress, including but not limited to an act conducted by mail or by use of a telephonic or telecommunication device or electronic communication device, including but not limited to a device that transfers signs, signals, writing, images, sound, data, or intelligence of any nature, transmitted in whole or in part by a wire, radio, electromagnetic, photoelectronic, or photo-optical system, including but not limited to electronic mail, also known as email, internet communications, instant messages, and facsimile communications. So here's the bulk of it. Here's the heart of it right here. So B, whoever willfully, either directly or indirectly, Roman numeral I, threatens, attempts, or causes physical, emotional, or economic injury or property damage to, Roman numeral II, or conveys a gift, offer of promise of anything of value to, or Roman numeral III, misleads, intimidates, or harasses another person who is A, a witness or potential witness, B, a person who is aware of information, records, documents, or objects that relate to a violation of a criminal law or a violation of conditions of probation, parole, bail, or other court order. C, judge, juror, grand juror, attorney, victim, witness, advocate, police officer, correction officer, federal agent, investigator, clerk, court officer, court reporter, court interpreter, probation officer, or parole officer. D, a person who is or was attending, or a person who has made known an intention to attend a proceeding described in this section. Or E, family member of a person described in this section with the intent to, or with reckless disregard for the fact that if it may, one, impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, a grand jury proceeding, a dangerousness hearing, a motion hearing, a trial or other criminal proceeding of any type, or a parole hearing, parole violation proceeding, or probation violation proceeding, or an administrative hearing, or a probate or family court proceeding, juvenile proceeding, housing proceeding, land proceeding, basically all the proceedings. Clerk's hearing, court ordered mediation, or any other civil proceeding of any type. Or two, punish, harm, or otherwise retaliate against any such person described in the section for such person or such person's family members' participation in any of the proceedings described in this section shall be punished by imprisonment in the state prison for not more than 10 years, or by imprisonment in the house of correction for not more than 2.5 years, or by fine of not less than 1,000 or more than 5,000, or by both such fine and imprisonment. If the proceeding in which the misconduct is directed at the investigation or prosecution of a crime punishable by life imprisonment, or the parole of a person convicted of a crime punishable by life imprisonment, such person shall be punished by imprisonment in the state prison for not more than 20 years, or by imprisonment in the house of corrections for not more than 2.5 years, or by a fine of not more than 10,000, or by both such fine and imprisonment. Hey, what's up, babe?
Hey. Oh.
Yeah, you'll need that. Happy day after your birthday day.
Thanks. I feel like I don't want to interrupt to like thank all the people I need to thank, but there's so many, so I don't know when we should do it.
No, right now is perfect. All right, so I just went through the statute in question here, at least the primary statute, which I feel is the one that really warrants the most conversation.
I thought you were gonna BS until I got here.
I've been on for 17 minutes, so I have been. How long did you? Oh, you thought I was gonna? Oh, just shoot the shit.
No, it's fine. Once I heard you like getting into it, I kind of just took my time. All right. Well, I want to thank like so many of you for your birthday wishes and all your super chats and donations. But I also want to thank Tracy and Mandy and Cami Q, Mags, Marissa, Kasha, Komama 23, J Beans, Sherry Hall, Chelsea, Ann Piccolo, Brandy Griffiths, Mandy, and Tracy for my I got coffee, lots of Starbucks gift cards that I can use, and a very, very generous Amazon gift. I was already like shopping, trying to find something worthy of the money that was raised. So I really, really appreciate all of you guys doing that. It was very thoughtful. All of you were very thoughtful, and I just wanted to say thank you to everybody.
And
Really means
Oasis
a lot.
created that great song.
Yes, Oasis created a great song.
She didn't
Thanks,
even know there was
Oasis.
sound to it. She was
Well,
like,
no, at first I just saw like the happy birthday and I was like, "Oh, happy birthday." Okay. And then I hear Bob listening and I was like, "What is that?" And he's like, "What are you talking about? You liked it already." So then I went back and I listened to it. It was very, very good. It was very thoughtful. You were all very thoughtful, and I
they
really
were indeed. They were
appreciate
indeed.
you all.
Okay. All right. So I went through the statute, and somebody kindly sent me. I saw your text, Trace. Thank you. And also thank you to Lindsay for sending me the charging documents, which I think is also going to be helpful to take a peek at. So let's do that. They're lengthy. So in terms of the charging documents, it's sum and substance is 9 pages, and then it's going to be probably the same basic concept for all of them, with some different factual scenarios. Like we'd have to do a whole live But I just want to give you guys an idea of what Aiden's been charged with in this case before we go to the hearing. And then before we hit that, I want to kind of skim through um Bradle and Bettero's motion to dismiss, and then we'll hit the hearing. Okay.
But do you need, I mean, like, is there, what is this, a Massachusetts statute? Because it says like a witness. Is there any definition of a witness? I mean, a witness in a case against you, is it not
Yeah,
limited?
I read through it all.
Okay, so was witness, the use of the term witness, because I was reading it when you had it up there, use of the term witness limited to a witness in a case against you?
No,
Hmm,
it was pretty lengthy in terms of
broad.
it was very broad. It was it was a witness in it was a witness or potential witness, a person who is or was aware of information, records, documents, or objects that relate to a violation of a criminal law or a violation of conditions of probation, parole, bail, or other court order, judge, juror, grand juror, attorney, victim witness advocate, police officer, correction officer, fed, investigator, clerk, court officer. It's tons.
Alright,
It's
broad, it's broad.
super broad, super broad. So, but what our concern here is, I'm curious because I've told you guys who've watched this channel on many occasions that states can afford more rights than the federal constitution, but they can't afford you less.
Right,
And in this particular, when you are dealing with this particular statute, when it's butting up against the First Amendment,
right.
that's where you get a problem with this. That's why this is an important case. And like I said, love or hate Turtleboy or Aiden, if you care at all about our Constitution, this is a case you have to be paying attention to, especially as it pertains to journalists.
Right, I mean, we're all out there screaming, we want people to to do investigative journalism. There's gotta be some level of confrontation,
Right.
not necessarily aggressive confrontation, but I'm just saying some level of confrontation if you're investigating someone and confronting them with questions that you have based on whatever it is, you're investigating.
And do your words, if you choose to use words like that are harsh in terms of your questioning, like, well, why did you murder this person? If that person is, if the reporter's alleging that they did it,
Right.
then is that crossing a line? Is that not a fair question? Is that not protected by free speech? I would argue that it certainly
I would
is.
argue that it certainly is too.
All
So
right.
like Bob was saying though, the federal constitution, it's the base. You can't go below it. So
All right, let's dig into this thing. All right. Okay, so I'm just gonna go through, like I said, the first one. So this is one of the charges. This is a 70-page document.
oh Lord, you're not
Yeah, no, I
yeah,
mean they hammered him. Like it's like this.
but I'm just saying we're not going through 70 pages right
No,
now, are we? Oh,
God no.
okay.
God, no, like no, absolutely not. But it's helpful. I mean, not
No, we
everybody
need to
knows
read
about
some
this.
of it. You
Yeah,
gotta
for
get the
sure.
general.
All right, so this is one of the intimidation of a witness charges, violation of MGL Chapter 268 13B. So on the morning of January 29, 2022, John O'Keefe was found unresponsive on the front lawn of 34 Fairview Road in Canton, Massachusetts. He was transported to Good Sam Hospital where he was pronounced deceased. The office of the chief medical examiner determined the cause of death to be blunt force to the head and hypothermia. Evidence was presented to the Norfolk. Is
Wait,
it
blunt force to the head. What about to that arm? Like I thought there was some blunt force to that arm. Sorry, go ahead.
presented to the Norfolk grand jury that indicted the night of January 28th, 2022. Reed and O'Keefe were at two Canton restaurants, CF McCarthy's and the Waterfall, where they met friends. After the waterfall closed at shortly after midnight, Reed and O'Keefe were invited to 34 Fairview. Witnesses stated that Reed and O'Keefe did not enter 34 Fairview Road. The Norfolk grand jury indicted Karen Reed on second-degree unaliving or homicide. It's actually M, though. Motor vehicle manslaughter while OUI.
Operating under the influence.
Correct. And leaving the scene of a motor vehicle crash causing death. The indictment alleges that Reed struck O'Keefe with her motor vehicle and left the scene. The case is currently pending in Norfolk or Norfolk. How do you guys say it out there? Norfolk or Norfolk?
Norfolk.
Nah, they don't pronounce anything the way
Norfolk.
I'll be
With a super accent, yeah, it's probably something.
Norfolk.
All right, just say Norfolk.
Superior Court. Somebody will let me know in here. I guarantee it.
Well, I already see them laying the foundation for it. This is our theory. So anything against that theory is clearly harassing because Karen Reed struck John O'Keefe with her vehicle. So why is he harassing people about things that are not consistent with what we just said happened?
See, Lindsay Bay. So somebody says it's Allie's correct, Norfolk, which is how I pronounce it. But Lindsay Bay says it's Norfolk. So I think I was right. It's Norfolk. So, okay. The lead investigator for the above investigation is Trooper Michael Proctor of the MSP assigned to the Norfolk State Police Detective Unit. Trooper Proctor testified before the grand jury and continues to conduct investigative work on the case. Proctor,
not no more.
Not no mo. Michael Proctor is married to Elizabeth Proctor. Elizabeth is not a witness to the investigation, but a family member, as mentioned in 268-13B. During the investigation into O'Keefe's death, witnesses were identified, interviewed, and testified before the grand jury. These civilian witnesses were present with O'Keefe and Reed in the hours leading up to O'Keefe's death and his discovery on January 29th of 2022. The witnesses include Matthew McCabe, interviewed by investigators. Matthew was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death, observed an SUV believed to be Reed's in the front of 34 Fairview Road and testified at the grand jury. His wife, Jennifer McCabe, interviewed by investigators. Jennifer was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death. She also claims to have observed an SUV believed to be Reed's in front of 34 Fairview. Was with Reed when O'Keefe was found unresponsive and testified at the grand jury. Brian Albert, interviewed by investigators. Brian was with O'Keefe and Reed at the Waterfall. He's the homeowner of 34 Fairview, and he testified at the grand jury. Julie Albert, wife of Chris, interviewed by investigators. Julie was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death and testified at the grand jury. Chris Albert, husband of Julie, first interviewed by investigators on February 10 of 2022. Chris was with O'Keefe and Reed at the Waterfall restaurant before O'Keefe's death and testified at the grand jury. Colin Albert, interviewed by investigators, son of Chris and Julie Albert. Strangely, we don't get any facts of where he was that night. That's interesting. And why he was called as a witness at all. And then Juliana Nagel, also known as Julie Nagel, interviewed by investigators. Juliana was present at 34 Fairview when people were arriving from the Waterfall restaurant and observed an SUV believed to be Reed's parked in front of 34 Fairview. So in an April 2023 motion filed by Reed's defense attorney's defense motion for order pursuant to Mass Rule of Criminal Procedure 17 directed to Brian Albert, Verizon, and AT&T, alleged police misconduct and a conspiracy among the civilian witnesses to frame Reed for the death of O'Keefe. The motion calls Brian Albert a suspect and Jennifer McCabe a conspirator who, quote, took calculated steps to purge her phone of this inculpatory evidence. A local blogger, Aiden Kearney, has adopted the defense's claims. Kearney runs a series of websites and social media accounts under the name Turtleboy.
Or has the defense adopted Kearney's claims?
No, the motions predated Aiden. Aiden, I was saying it. Aiden's really the one who turned this case into what it is right now in terms of national publicity. There's no
Oh, so the
denying.
defense already was on that track and then he brought it to light.
Yeah.
Okay.
Like they had filed a motion to dismiss that kind of laid out their whole theory. That was out there for a hot minute. And then Aiden ran into it and he's like, holy shit. And then started reporting on it. So the social media accounts include TB Daily News, X, formerly Twitter. He's got 33,800 followers. I think he's got more than that now. Aiden Kearney at Dr. Turtleboy, X, formerly Twitter, 44,800. Turtleboy, Facebook, 27,000. Turtleboy Live, YouTube, he's got over 100 now, but 41 at the time that he was charged. And then Kearney refers to his followers as Turtle Riders. Paragraph 6, beginning in April of 2023, Kearney began posting articles to his website and social media accounts where he adopts the defense allegations as true and makes personal attacks on the civilian witnesses, members of their family and their friends. Kearney authors and publishes a blog on the website tbdailynews.com. The website has a series of articles entitled Canton Cover Up. As of September 28th of 2023, at least 164 articles have been posted to the website under this category. I think he's over 400 now. He's got a shit ton on there under this category regarding Karen Reed. Kearney posts weekly videos to YouTube where he has discussed Karen Reed and made statements regarding witnesses. Below are a small section of verbal statements made by Kearney in these videos that have been published to followers and are publicly available for viewing without being a subscriber or follower and have been archived by investigators. Episode 594, Turtleboy returns to Canton. Video posted shortly after Kearney visited the homes of witnesses. So these are some quotes they're putting in there. So these are the things they're alleging are in violation of the statute. This is not my last trip to Canton. I will be back. Okay. Another bullet point. I'll be back. Get used to this.
So they're not even saying who he's saying this to.
Correct.
Okay.
So he says, these people think that I'm fucking around and you haven't seen the last of me. Get used to it. Get used to it.
So based on what we've read thus far, it would seem, at least based on the way they're laying it out, that you're supposed to assume this was said to those, one of those witnesses, one of the witnesses in the Reed case.
Right.
I mean, they haven't given us any reason to think anything else. And
yeah,
I don't think that that's accurate is what we're going to come to learn, but that's what the way it's written, the way it seems.
Right. That's the way they're couching it. Episode 598, breaking Karen Reed, defense files motion to recuse. So bullet point, this guy, Chris Albert, has his head on a swivel looking for turtle riders. Quote, I got bad news for you, Chris. I got really bad news for you. They're literally everywhere. End quote. Quote, you guys should just stop going out in public. It's only going to get worse from here. I know where y'all were today. You guys were in Agawam. Is that right? Agawam? What kind of name is that? I'm assuming it's indigenous, maybe. Weren't you? You guys were at some sort of little league thing in Agawam.
I mean, I wouldn't be happy if somebody's tracking me at little league stuff with my kids personally. So
it's not about if you're happy. It's about whether you have a First Amendment right to say it. You know what I mean? That's ultimately what this boils down to. Alberts, McCabe's, all you people, because if you're not happy to the extent you have other remedies that aren't being charged with a crime.
Right. No, I agree. Obviously I agree.
Yeah, you've got civil court.
Right.
Or you go in and get an order of protection.
Right.
Those are the remedies for you available to you under the law, not weaponizing the statute. Alberts, McCabe's, all you people were there. There will be no life as normal is over. Life as normal. You had normal for a while there from January 29th to about April of 2023. You guys literally got away with murder. 8-minute mark. While discussing video of Chris Albert being confronted outside of a Canton restaurant, Kearney and his audience are getting to them. Chris Albert and other witnesses. When you act this way, That's like a green light for me to hit the gas, 19-minute mark.
All this stuff is out of context. I can't even. I'm not going to comment on any of it anymore.
I mean, there's like half his shit is done, tongue in cheek. Half of it's, I mean, it's satire, but it's also for him the truth.
Right.
I mean, for him, he believes it's true. So,
Just like the state believes that Karen hit
right.
John O'Keefe.
Just like all the people that are saying Karen's a murderer. There's no difference. I mean, yes, she's been charged, but it's the exact same concept.
Right.
So,
She's not been found guilty.
correct. She's presumed innocent. So, quote, I got pictures of you. You can't leave the fucking country. Turtle riders were going to find you. They're going to find you. You can't hide anymore. Your private life is officially over. Over. You leave your house, you're going to have your picture taken. So you need to get used to the new normal, your new normal. Turtle riders are going to take pictures of you and they're going to send it to me. You're famous. We need to accelerate it. Quote, the woman who recorded the video, Chris Albert confrontation, are doing a fantastic job with this. 24-minute mark. So episode 604, Colin Albert drops out of school. Brian Higgins flipping, ? Is the end near? Bullet point. I said from the beginning, I don't want this to go to trial. 17-minute mark. Paragraph 8 on September 13th.
Completely out of context. Completely no context.
I mean, they're plucking a sentence out of like 3-hour lives and sticking it in here with no context. I mean, so on September 13th of 2023, Kearney posted a blog entitled Canton Covered Up, Part 142. Free Karen Reed billboard goes up on Route 1 outside Gillette Stadium in Foxborough. 2 more to follow on his website. The topic of the blog post was about a billboard that Free Karen Reed with a picture of Karen Reed. That read Free Karen Reed with a picture of Karen Reed. Kearney praised the organizer of the billboard. In the post, Kearney wrote, "Thank you to everyone who donated as well. Although millions of people know about the injustice that is happening in Norfolk County, I would bet that over half of the population in Norfolk County has never heard of Karen Reed before. That will change because of this three-pronged billboard blitz. It's really important for people in Norfolk County to know about this story because this is where the jury pool will be chosen from." Emphasis added.
So paragraph 8 should be deleted, stricken from the whole thing. There's literally not even an allegation in there that could be even considered intimidation, harassment of a witness. It should be literally stricken.
Right.
Disregard.
So on June 13th, Kearney broadcast a live YouTube video, episode 590, which is currently posted on his YouTube page. During the broadcast, Kearney displayed phone records of Jennifer McCabe from the day O'Keefe was killed. The records displayed names next to the phone number, which appears to be the user of the other phone number. These records had previously been an attachment to an unredacted defense motion filed in Commonwealth v. Reed. During the video broadcast, Kearney cold calls the phone numbers without names associated. In this process, Kearney called a work cell phone number of Trooper Proctor. Trooper Proctor stated the phone number that made the call was 41, that number there.
So what, he's not allowed to do that? What's he not allowed to do that?
I don't know. I mean, they did it here in this pleading and didn't redact it. And I'm assuming that's Aiden's number. Kearney left the following voicemail. Hi, Trooper Proctor. This is award-winning journalist Aiden Kearney calling. Spelled Aiden's name wrong there. I'm calling to talk to you. I have some questions about you. I have a lot of questions, actually. For starters, why didn't you tell me, one, before doing the investigations, that you were good friends with the Albert family? Why did you, in your report, say that you were introduced to Chris Albert on February 10th when you have known him for more than a decade prior to that? Why did you lie about what time you towed Karen Reed's car? Why did you intentionally misspell the names of several key witnesses in your report? And, I'm just wondering about all those things. And maybe I can meet up with you for coffee. Boy, do I have a lot of questions for you. When you were inside Fairview Road that night, or that morning rather, why did you stay there for 4.5 hours? And what did you guys talk about and do? And why were you descending the stairs with John O'Keefe's phone in your pocket? So give me a call back, man. We feel like you and I have a lot of catching up to do. I talk about you a lot. I feel like I know you pretty well at this point. I know which year you graduated from the academy. I know you were out in West Brookfield for a while. I know some people that know you. So give me a call back when you get this. Now that I have your number and everybody watching also has your phone number, which is again number. So I'd like to know. She called you again. You called her at 12:49. We're going to get to that. So now that I have your number, I'm going to plug you in and we'll talk soon. Bye.
Stricken. There's nothing in there. And like you said, if it got to the level of harassing, once someone tells you you're not allowed to call me, you're not allowed to talk to me, then the step is go and get an order of protection. And if it rises to that level, then a judge will say they can't call you. And then if they call you, guess what? Now it's a crime.
Right.
That one's stricken. Stricken.
Okay. So 10, as a result of the cell phone numbers being broadcasted, Trooper Proctor began to receive random and harassing text messages and voicemails in the 12
wow.
hours following Kearney's calls. Trooper Proctor received approximately a dozen text messages, phone calls, and voicemails. The content of the calls and messages pertain to Trooper Proctor's alleged involvement in the conspiracy and called for his termination. Trooper Proctor had to change his work cell phone number to avoid constant unwanted calls and messages.
Oh, poor Proctor.
Proctor is married to Elizabeth Proctor.
Or
Beginning in
wait,
April.
strike it. Gone.
Okay. So Michael Proctor is married to Elizabeth Proctor. Beginning in April of 2023, Kearney wrote blog posts about Elizabeth Proctor. On May 29, 2023, Kearney authored a post about Elizabeth. A video is attached to the post. The video depicts a cell phone screen of an Apple iPhone. The user of the cell phone dials the cell phone number of Elizabeth, which is displayed on the screen. Kearney further writes, I can think of two people who deserve to lose their jobs over this alleged conspiracy against Reed, though. Michael Proctor and Elizabeth Proctor. These two lowlifes think they're untouchable. They're nothing but bullies who terrorize people for years. Well, but now they've met their match.
Strike it.
12, in the post, Kearney states Elizabeth works as a human resource manager at Instron and posts the main phone number for the company. The post then states, but you're probably not going to reach anyone that way. So feel free to leave a review on their wide open Facebook page or on their Twitter account. You gonna keep that one?
I don't know. But is there something that prevents people from taking to, like, let's just put it in a whole different context, whatever context you want from, I mean, it might be harassment at her place of business.
That's not the statute. Like, so this is in particular, intimidation of a witness.
Right. So I guess I'm thinking of it like, would it rise the level of being able to get an order of protection? And maybe some of this would, like, especially if you're having people call people at their place of business. But
Yeah, I mean, and again, that's the remedy available under the law. Like,
right.
That's where this whole thing lies. It's like you've got the ability to sue for libel and defamation and slander and all those things, and then you've also got the ability to go in and get TROs.
And
Sure.
then you can weaponize a TRO. You don't get the crime before the TRO.
See, and Kaylee's saying that they have gone in and tried to get them, and they've been denied by a judge.
Well, then there you go. I mean, that solves that. If it's not even sufficient to get a TRO, how in the hell is it rise to a level of a criminal offense?
So
Thanks, Kaylee.
So then on May 10th of 2023, Kearney broadcast a live YouTube, which is currently posted on his page. Kearney talks about Elizabeth. He stated he was going to call her. He repeated her cell phone number on the broadcast as he was entering the number into his cell phone. Using the speakerphone option on his cell phone, Kearney broadcasted the phone call. Phone call went to voicemail. Elizabeth stated the phone call came from his number. Kearney left the following message. Hi, Elizabeth. This is Aiden Kearney calling you back from Turtleboy. We briefly spoke yesterday on the phone. I introduced myself to you, and then you hung up on me. Or maybe it was a bad connection, but I just wanted to see how your day at work went today. If it went well, I noticed that your employer took down their social media pages within minutes of the blog I published about your recent behavior. And I just wanted to see is it awkward? Were you afraid to go in? Just tell me about your day and why, because that's the part I don't understand is that you seem to be okay with calling other people's workplaces and interfering with their ability to make a living for themselves. But when it happens to you, maybe it's not as fun. Maybe it's not as fun. Do you like that? That's what I want to know. Did you like that? Because you've been doing that to a lot of other people. And do you think it's fair that it's happened to you, dear? Do you regret it? Do you regret it? And what's your scumbag husband up to right now? Are you going to visit him in prison? Do you think that they'll have conjugal visits? Give me a call back when you get this, and we can chat some more. Bye, girl. So 14, following the phone call, Kearney accessed social media accounts of Instron and laughed as he stated the pages were taken down and stated the Turtle Boy effect. Oh God. So both Michael and Elizabeth Proctor say that they've felt harassed by the acts of Kearney.
All right. Well, like you said, I mean, it makes no sense because Kaylee says they tried to get an order of protection, were denied. Like that, it's like that's been decided then.
All right. So there's another one. Anyone in Canton want to take a couple pictures for me? DM me, please. And then he posts something on Twitter. Photo depicts the front of 6 Wentworth Road, home of Michael and Elizabeth Proctor. The white Jeep Wrangler in the photograph belongs to Jen McCabe. Parked today at 6 p.m. Jen McCabe's Jeep was seen parked outside the Proctor household. We ran the plates on all 3 cars. They're registered to Michael and Elizabeth Proctor and Matt McCabe, Chief Rafferty in the DA's office that said they don't know each other.
This is investigative reporting. This here is.
Yeah. Well, I think originally, and they referenced this in the hearing, they talked about that this particular individual they initially charged, but then suddenly the charges vanished. They got dropped.
Wait, what do you mean?
Because he says here we ran the plates, which would assume typically only law enforcement, and then obviously PIs that have access. You can't just run plates as an individual.
Well, I mean, no, but so who is saying that they ran the plates though?
They don't say, but they figured it out. And I think that they charged her, but the charges got dropped. All right. So you guys get the idea. All right. It's like we could go on forever. It's like I said, there's 70 pages.
Yeah, we're not going to do that.
We're not going to
I'm sure they touch on that. Well, wait, but I do want to see the charges. Like, where are the counts of like what he's actually?
So I think he's got 8 counts of here. Somebody throw it up in the chat. What the breakdown of the counts is. I think it's 8 counts of the intimidation of a witness, 5.
So that's what you read is MGL 268 section 13B earlier.
Wait, what? Yeah, this is the one that I read.
And all right.
Okay. So we're gonna switch over. So did you have a chance to look at this at all?
I mean, no, I looked at some of it, but it's 40 pages. So
yeah. So I mean, it basically sounds in constitutionality, heavy constitutionality. So Kearney, by and through his undersigned counsel, hereby moves the court dismiss all 16 indictments before the court for A, lack of probable cause that a crime was committed where the charges implicate only protected speech, and B, the prosecutor's impairment of the integrity of the grand jury by misrepresenting the state of the evidence and the law before the grand jury in a manner material to obtaining the indictments in violations of Article 1, 10, 12, and 16 of the Mass Declaration of Rights and the First and 14th Amendments to the U.S. Constitution and their progeny. So Mr. Kearney requested each indictment be dismissed upon a written and published judicial declaration that the alleged conduct laid before the grand jury is protected speech under Article 16 and and under the First Amendment. Okay, so
we don't need the background, right?
Yeah, we don't need the background.
Well, you can read this first part actually because
yeah.
Yeah.
it kind of gives the background. So, Mr. Kearney is an award-winning investigative journalist who owns, reports from, and operates a number of news outlets that broadcast over the internet through YouTube, Facebook, X, and his own website and web pages. He live streams news, investigates matters of public concern, key phrase there, public concern, and often breaks stories by conducting investigations into matters neglected by law enforcement before viewers' very eyes live on the air. He offers pointed and unapologetic commentary to his viewers, which numbers in six figures and cumulatively reach into the millions. He protests, urges boycotts, engages in political hyperbole, satire, rhetorical confrontation, questions investigative targets, petitions the government for redress, and exposes corruption by government officials. He practices advocacy journalism and provides in-depth, well-sourced factual reporting, often accompanied by a call to action for justice and truth. So the indictments against Kearney stem from his investigative reporting on a pending murder case in Norfolk Superior Court, Commonwealth v. Karen Reed. So Kearney is an outspoken supporter of Miss Reed, who strongly believes that she was framed by numerous individuals, including members of the Massachusetts State Police, MSP, who are prosecuting him, members of MSP who are witnesses against him, and numerous civilian witnesses against Reed. Mr. Kearney's reporting on the case included his detailed series Canton Cover-Up has garnered national attention. At present, Mr. Kearney has published 465 articles on the case. His reporting has broken several notable developments in the case, many of which involve the very witnesses he is alleged to have intimidated. So consequently, his reporting and advocacy journalism have severely criticized Norfolk County prosecutors and state police assigned to the Reed case, which in turn has led them to weaponize the Massachusetts Witness Intimidation Statute against Mr. Kearney with the intent to silence his criticism of their alleged misconduct in the Reed investigation and prosecution.
I would have added and prevent further investigation.
Yeah, like, well, they did. He said they're trying to silence him.
Yeah.
So we got a redaction. Indeed, redaction, electronic communications illustrate the Commonwealth's intent to silence Mr. Kearney by exploiting that fundamentally flawed statute. Shortly before Mr. Kearney's arrest for months-old conduct, blank, who referred to Mr. Kearney as blank, outrageously and recklessly texted blank, and three other unknown individuals. So those are redacted.
Is that a footnote or no? Is that a quote? Oh, that's like a quote that's redacted.
So then he gets into the applicable law. So the probable cause to indict. Now this is relating to the grand jury proceedings themselves, and the grand jury performs the dual function of determining whether there is a probable cause to believe that the suspect has committed a crime and of protecting citizens against unfounded criminal prosecutions. So he cites some cases. In order to obtain an indictment, a grand jury must be presented with, quote, reasonably trustworthy information sufficient to warrant a reasonable person in believing that the defendant has committed the offenses charged. So probable cause requires, quote, more than a suspicion of criminal involvement, something definite and substantial.
So, I mean, that's a little bit different in Massachusetts, that they require reasonably trustworthy information be presented.
Right.
I mean, it just is, because typically you can't really attack the credibility of the evidence presented to a grand jury, at least not in the states that I've practiced.
All right. So although courts ordinarily do not, quote, inquire into the competency or sufficiency of the evidence before the grand jury, he cites Commonwealth v. Robinson, quoting Commonwealth v. Galvin, a judicial examination of whether probable cause existed at the time of the incident is a clear exception to that rule.
Indictment, at the time of the indictment.
Oh, yeah. What did I say?
Incident.
Oh, yeah. Here, the First Amendment protects Mr. Kearney's speech and opinions about a matter of public concern, such that there is no probable cause of criminal activity. In short, Mr. Kearney's speech is protected as a matter of law under the First Amendment and Article 16, Further, principles of third-party liability and their absence in this presentation firmly establish that the Commonwealth has failed to implicate Mr. Kearney in any supposedly criminal activity sought to be attributed to him by third-party fellow demonstrators, whistleblowers, or other internet posters or commenters. So then you got 2 is the footnote here. Mr. Kearney does not imply or believe that any of his fellow demonstrators or internet bloggers or commentators engaged in any criminal activity. In any event, he would not be responsible for any such conduct, and nowhere in the grand jury was any foundation for joint venture liability ever referenced or attempted to be established. So grand jury indictments should have been dismissed where absence of evidence of knowledge and shared intent, consciousness of guilt, evidence held insufficient to support indictments. So mere presence coupled with the failure to take affirmative steps to prevent a crime is insufficient for criminal liability. So then he's talking about impairing the integrity of the grand jury, which is a pretty interesting argument too, but we're going to kind of whip through it because I want to get to the meat. So C, the witness intimidation involving speech is strictly limited to narrow exceptions to the First Amendment. The Commonwealth ignored such limitations in its presentation. So the alleged witness intimidation charges concern Mr. Kearney's reporting on the Reed case, including his online updates, live shows discussing the case, appearances at demonstrations, and his expressions of opinion about the conduct of certain individuals in connection with that case. The witness intimidation charges at issue depend on certain conditions precedent, such as evidence that the alleged offender intended to, quote, mislead, offer a witness anything of value, threaten, harass, and attempt to cause emotional or economic harm. So, however, the First Amendment and Article 16 limit these potential violations when the alleged means of the crime is a person's speech. The Constitution, quote, demands that content-based restrictions on speech be presumed invalid and that the government bear the burden of showing their constitutionality. He cites Ashcroft v. American Civil Liberties Union. So the carve-outs where speech may be regulated are few and narrow. In U.S. v. Alvarez, the U.S. Supreme Court set forth the entire field of exceptions as follows. You want to read this?
In light of the substantial and expansive threats to free expression posed by content-based restrictions, this court has rejected as startling and dangerous a free-floating test for First Amendment coverage based on ad hoc balancing of relative social costs and benefits, citing a U.S. Supreme Court case from 2010. Instead, content-based restrictions on speech have been permitted as a general matter only when confined to the few historic and traditional categories of expression long familiar to the bar, and that would be the legal bar. Again, that's a U.S. Supreme Court from 1991. Among these categories are advocacy intended and likely to incite imminent lawless action. Again, citing a U.S. Supreme case from 69, another from 73, and another from 64. Obscenity. So to incite imminent lawless action, obscenity, defamation, and some limits on liability for defaming a private figure, speech integral to criminal conduct.
That was a public figure, not you forgot the providing substantial protection for speech about public figures.
Correct. And then and that then there was a case saying that imposing some limits on liability for defaming a private figure.
Right.
So-called fighting words, fraud, true threats, and speech presenting some grave and imminent threat the government has the power to prevent. Although a restriction under the last category is most difficult to sustain. Again, citing a United States Supreme Court case. These categories have a historical foundation in the court's free speech tradition. The vast realm of free speech and thought, always protected in our tradition, can still thrive and even be furthered by adherence to those categories and rules. And that cites to Alvarez case Bob mentioned earlier.
Okay. Do you want me to read?
Oh, I didn't know if you just wanted me to read like that site.
So
that you were-
I just kind of wanted to get to like the thrust of this argument. Then we're going to go to the hearing. So, but so everybody's saying it's Kearney. Like, why do you guys have to pronounce everything wrong in Boston and in Massachusetts? It's clearly Kearney.
No, it's however the man says his last name. That's what it is. So
That's true because like
what is it? Kearney?
Kearney.
Right.
Here, the Commonwealth merely alleges that the Reed witnesses and investigators suffered emotional or economic harm and or were placed in fear by Mr. Kearney's exercising of his First Amendment rights to report, question, demonstrate, and advocate on important matters of public interest, including arguments advanced in the Reed case that she was, quote, framed by the very people that Mr. Kearney is accused of causing emotional and economic harm. The First Amendment does not cease to protect a journalist's non-threatening opinions simply because such speech allegedly has caused economic or emotional harm to a witness or other related persons under the statute. If anything, it is precisely in these situations in which the First Amendment must protect a person's right to report on and express their opinion on a matter of public concern.
Alleged harassment by speech which purportedly causes another economic harm or emotional injury, which impedes or otherwise interferes with anyone connected to a proceeding or a proceeding itself, assuredly is protected speech by the First Amendment and therefore unconstitutional under Massachusetts State Supreme Court case O'Brien v. Borowski from 2012. Where, as here, words or expressions form the basis of the alleged violation, only true threats or fighting words can be the target of the statute. Unquestionably, all of Mr. Kearney's opinions and expressions are exempt from the statute because they are not true threats or fighting words. In these circumstances, Massachusetts Witness Intimidation Statute 268, Section 13B, which prohibits the causing of economic or emotional harm through non-criminal speech, i.e., aside from true threats and fighting words, is unconstitutional on its face and as applied to Mr. Kearney.
So in Snyder v. Phelps, which is a U.S. Supreme Court, the court illustrated how the First Amendment protects a speaker even where repulsive, non-threatening speech may have caused substantial emotional harm to another. There, the family of deceased Marine Lance Corporal Matthew Snyder filed a lawsuit against members of the Westboro Baptist Church who picketed near his funeral while displaying signs that said, "Thank God for dead soldiers and fag troops." In reversing an intentional infliction of emotional distress judgment for the plaintiffs, the Fourth Circuit held that this highly offensive and cruel speech was protected by the First Amendment, quote, notwithstanding the distasteful and repugnant nature of the words, end quote. Furthermore, the Supreme Court has recognized that, quote, speech on matters of public concern is at the heart of the First Amendment's protection, Dun and Bradstreet Inc. versus Green Moss Builders.
So keep that in mind, what Bob just read and how horribly offensive that is when you're comparing and contrasting everything that's going to get brought up in the hearing today.
Right.
They used to have, they kind of changed the intentional infliction of emotional distress. When Bob and I were in law school, the example they gave was somebody saying you're as gay as a $3 bill. Remember that?
Mm-hmm.
And that was offensive, so highly offensive that it might constitute intentional infliction of emotional distress. Whereas a lot of statutes now say there's got to be some physical manifestation of this stress. They've tried to tighten up on it, but here the court is saying, especially when it is speech on matters of public concern, which is undoubtedly the case here. Repugnant and offensive is not enough. All right,
So
I
the
think you got the
yeah, I just want to get down to, because what really carves it out is O'Brien versus Borowski.
so go
Like
ahead, give us that.
that's the one that shrinks it down in terms of the statute, because the statute's overly broad. And it's I don't think there's another state that has a statute that's this broad. I mean, you could apply this in so many different ways because it's so broad. So in O'Brien versus Borowski, 2012 case, the Supreme Judicial Court addressed the Massachusetts criminal harassment statute and its inherent conflict between the protected speech of a defendant and its possible impact on an alleged victim. The court held that an illegal harassment was limited to fighting words or true threats, and interpreted the meaning fear to mean fear of physical harm or fear of physical damage to property. So, in other words, the SJC has made it abundantly clear that an individual's claim that another's non threatening speech has caused her to suffer emotional or economic harm, or that they are in fear of non criminal consequences, may not be criminalized under the First Amendment. The O'Brien court decisively held that allegedly instilling subjective fear in a person does not give a prosecutor a basis to charge them. Quote, an intent to cause fear, however, is less certain to be consistent with a true threat unless we narrow what it is that must be feared. As the U.S. Supreme Court of Appeals for the Seventh Circuit noted, there are types of threat that may, quote, contain ideas or advocacy, such as a threat to picket an organization if it does not yield to a demand to take some social or political action. And that comes from U.S. v. Velasquez. And such a threat may cause a fear of economic loss, of unfavorable publicity, or of a defeat at the ballot box. But such fears cannot be enough to make the threat a true threat that may be prohibited as civil harassment under the First Amendment and Article 16. There is nothing in the language of that act, or its legislative history to suggest that the legislature intended, quote, fear to mean more than fear of physical harm or property damage. And such a limiting interpretation would effectuate the legislative intent to confine the prohibited speech in the act to constitutionally unprotected speech. Therefore, we narrow the meaning of fear under the act to fear of physical harm or fear of physical damage to property.
And that's just a civil statute for harassment, not a criminal statute.
Right. So the Commonwealth also elicited conclusory testimony that certain complainants, such as Elizabeth Proctor and Juliana Nagel, felt threatened. See infra. A threat is a legal term as defined under Massachusetts law and requires 4 elements as set forth in the model jury instruction. A threat to commit a crime. The defendant is charged with having threatened to commit a crime against a person or property of another, threatening a person with a crime against his or her person or property. A person by threatening a crime against someone else or their property is itself a crime. In order to prove the defendant guilty of this offense, the Commonwealth must prove 4 things beyond reasonable doubt. First, that the defendant expressed an intent to injure a person or property of another, now or in the future.
All right,
Second,
so don't forget that first. Defendant expressed an intent to injure a person or property of another.
right.
And I don't know. I mean, we'll see what they get to. If there's such a threat, we'll see it, I guess.
Right. That the defendant intended that his or her threat be conveyed to a particular person. Third, that the injury that was threatened, if carried out, would constitute a crime. And fourth, that the defendant made the threat under circumstances which could reasonably have caused the person to whom it was conveyed to fear the defendant had both the intention and the ability to carry out the threat. So the third element demonstrates the lack of probable cause to sustain indictments on such a theory. Mr. Kearney's speech did not threaten injury from a crime and therefore did not run afoul of the Borowski rule. Rather, he expressed his opinion and common sense conclusion that people who lie may experience harm and discomfort, but he never threatened any criminal action whatsoever. In any event, under the First Amendment, even literal threats are limited as a basis for prosecution unless they constitute true threats. So in Watts v. United States, Watts at a public rally expressing his opposition to the military draft said, quote, if they ever make me carry a rifle, the first man I want to get in my sights is LBJ, end quote. He was convicted of violating a federal statute that prohibited, quote, any threat to take the life of or to inflict bodily harm upon the president of the United States, end quote. the U.S. Supreme Court reversed, interpreting the statute, quote, with the commands of the First Amendment clearly in mind, end quote. The court found that Watt's speech was protected under the First Amendment because he had not made, quote, a true threat to assassinate President Johnson, but instead had indulged in mere political hyperbole. So if a legal definition must be affixed, the words qualify as political hyperbole, where, quote, in the light of its context, did not constitute a knowing and willful threat and was protected by speech.
And that goes back to what we were saying in the beginning. All of those like statements, there was no context. There, without context, we cannot say if anything is, you know,
A true threat.
Right.
Right.
All right,
So
I think we get it, unless there was something else big that you thought really.
no, I mean, like the whole thing's pretty interesting, but I think in terms of like getting enough to get us to where we need to be so that
Go to the conclusion.
oh, okay. I gotta pull it back up. It's long.
Yep. I guess we could have read the captions.
It's all right. Mainly the thing that, because I think Aiden went through this on his channel anyway, but I think that
I'm sure he
the
did.
main purpose is to go through, you know, so that people have an understanding what they're seeing in the hearing and like why the judge is asking certain questions. So, and I think kind of getting into just some Alvarez and Borowski was enough. All right. So that's conclusions.
Oh,
Very short.
Okay.
All right. Okay. So let's pull up the hearing. I'm pulling it from Aiden's channel. He put it up yesterday.
Did you? I mean, I guess he doesn't matter, but did you ask him?
I did. He's fine with it. Okay.
Right. Leah says, yeah, like, but is she protected against having her feelings hurt?
Mark 3, let me just update this. Mr. Kearney is present and represented by attorney Timothy Bradle and Mark Federer. The Commonwealth is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for hearing on the defendant's motions to dismiss. If the parties could please identify themselves for the record.
Morning, Your Honor. Robert Cosgrove for the Commonwealth. I guess it's a late morning. I should have said good afternoon.
Hello, Your Honor. Timothy Bradle on behalf of Aiden Kearney. He's here in my, to my left. And Mark Federer for Mr. Kearney.
Mr. Federer. Good afternoon. Okay, so I got the motion and I got the response.
Can you hear it?
Why don't I do this? I've got some questions that I'll throw out at the beginning, and maybe both sides can answer them. Why don't I start with the defense and then I'll go to Mr. Cosgrove. So, Mr. Kearney certainly a journalist. He's a savage. Mr. Bradle, where's the line? How far can he go to satirize things? And when does it become a crime? I asked that to Mr. Cosgrove as well to address. How does the conspiracy counts, which are 14, 15, and 16, how do they fit into this? How is that intimidation? Are there people that are mentioned in these indictments who are non-witnesses, specifically as to counts 5 and 15? Tell me, Mr. Bradle, where you think that the motorcade, how does that fit into this? Where is the intimidation there, Mr. Cosgrove? You can obviously speak to that, but Mr. Bradle, I'll start with you.
Thank you, Your Honor. You know, as usual, Judge, you come right to the point, and I appreciate that. You know, we have about 75 pages between counsel and I, and I'm happy to answer those questions. The first, where do you draw the line thing, Judge?
Yeah,
Wait.
sure. So
Pause it.
He's got his blog, he's got the website. I'm sure.
Never mind. I was going to say I thought he was addressing his question to the Commonwealth, but the
He
defense.
does both. He will. He addresses it to both. He was just kind of like giving a prefacing
Right.
it by saying what he's going to
It's
ask.
great for the judge to let you know what issues that he's thinking are issues so that you can focus right where he wants.
Right.
He gets a lot of activity, and he's covering a case. So he's acting as a journalist. But how far can he go?
Sure.
You know, and I say this to Mr. Cosgrove maybe as well. How about Michael Moore or somebody like that, or somebody who's a satirist in some way? I was trying to bring attention to a certain thing. How far does the First Amendment go in their protections? Go right ahead, Mr. Cosgrove.
Thank you very much, Aaron. Judge, it is actually a clear.
See, like that was interesting that the judge brought up Michael Moore, because Michael Moore gets into some shit, you know? I mean, Michael Moore does a lot of the same shit that Aiden does, you know? And then he makes really huge documentaries about him that millions and millions of people see. But I thought it was interesting that the judge brought that up. Kind of gives you a little window into what this judge gets into a little bit.
Clear line. If it's O'Brien v. Borowski. Okay, Judge, I know you're all over this. O'Brien says that all of these strictures that talk about speech and distress and everything else, it's limited to true threats and fighting words. O'Brien says that. Watts in the Supreme Court says that. This is just well-settled law. It's unquestionable. So it has to be true threats or fighting words when the issue is speech. And that's what we have here, we contend, is this is just Mr. Kearney's speech.
How about if he says words to the effect I'm gonna ruin your life? Is that enough?
No, it's not enough
Okay.
because it's not a specific threat in terms of any criminal behavior. And that actually is specifically addressed in O'Brien, and it's Snyder v. Phelps, Judge, Snyder v. Phelps. That's the Westboro Baptist Church case where they picketed a dead soldier's funeral. I mean, the most repugnant stuff you can imagine, but it's inflicting emotional distress in public on a matter of public concern is protected. So, and O'Brien specifically talks about that the fear needs to be defined. It's fear of property damage or being a victim of a crime. It's not fear of being sued. It's not fear of being embarrassed. It's not Ms. McCabe in Stoughton District Court saying, is there any way you can get him to stop blogging about me, Judge Walsh? That's not the fear we're talking about.
How about calling in phony pizza orders at a pizza restaurant?
You know, I'm glad.
Wait,
you brought
I
that
need
up,
a
too.
translator.
There's no evidence whatsoever, and he did do that.
Pause it.
He said, how about calling in phony pizza orders?
Again, I mean, I still think, but go ahead. All right. Is there, because like yesterday I had the closed captioning up on my screen, so it played on
I'll see
this.
if-
Oh, there you
okay.
go. All right. And then let's take
Mr.
the,
Kearney did not tell people to do anything with respect to that, but more to the point of
See how the closed captioning spells Kearney? Just for the record.
our motion here today. There's no evidence of that. You know, I don't want to sound sneaky when when I say, oh, there's no evidence of that. He didn't do it, A, and B, there's no evidence of it. And that's what we're here for, is to look at the evidence in the grand jury. There's no evidence whatsoever that he told anybody to inflict economic harm on the guy. Even if he did, which he didn't, how is that a crime? It might be something he could be civilly sued for, but it's not a crime. But the most important point on that, Judge, is that he didn't do it, and there's no evidence of it. That points up something that we want to address as well, Your Honor, is the idea that there's so much imputed derivative liability infecting these grand jury minutes. It's ridiculous. You know, it's as if the Commonwealth just basically forgot about the notion of joint venture and just wanted to attribute every bad thing that has happened to any one of these complainants to Mr. Kearney. I'll give you a ton of examples. Proctor says people drove by and spit on my lawn or whatever. That's got nothing to do with Mr. Kearney. They have no evidence. He said, hey, let's get into joint venture here for you to drive by and spit on his lawn. It's got nothing to do with Mr. Kearney. Another example that should throw out the entire case is McCabe. Jennifer McCabe says, I got an email that someone was going to rape me on my front lawn. That has nothing to do with Mr. Kearney. The fact that there are other people, many of whom are in this room supporting the First Amendment and supporting Mr. Kearney, that are concerned about this and that speak out, Mr. Kearney is not responsible if they cross some line.
You're not saying one of those people sitting
It's
there
not
said
his
that.
cross to bear, Your Honor. If the government wants to make a joint venture case, let them try, but they certainly haven't here. And that's the most important point, is that all of these derivative liability things, you got to throw those out the window, Your Honor. You can't use them as a basis to uphold an indictment, but also there's no evidence of it. There's no evidence that he did anything wrong. So all those derivative liability things, Judge, I hope that, I know you've looked at everything. When you look at it again, it can't apply to Mr. Kearney. It's just not within the law. It's not even, Zanetti, defense lawyers talk about Zanetti all the time, about how broad it's become. It doesn't even come in the galaxy of Zanetti. There's no evidence that Mr. Kearney urged anybody to call the pizza man and, order things and not show up. There's no evidence about the Proctor thing. He's got nothing to do with the Jennifer McCabe emails. All these things, Judge, are the government's attempt to just throw enough mud at him so that a judge who's swamped with these things says, there's all these allegations. I know you're not going to do that, and that's why we're here in front of you, is because we have every bit of faith that you're going to look at this in the way that it needs to be looked at, and that you're going to look at it on the right side of the First Amendment, Your Honor. The derivative liability stuff's got to be out the window.
Okay.
Can you refresh my memory on your next question, Your Honor?
I think I had asked a couple of questions, one of which was, where is the line, the conspiracy, which I think you talked about,
Yes.
and then the motorcade, which you talked about as well. How about the one with people who, in counts 5 and 15, who are at least, it's the same person, but are, it's intimidation of a witness. Is that person a witness?
And I just don't have it in front of me, Judge, in terms of 5 and 15 is the allegation. Elizabeth Proctor, yes, she's not a witness, but the breadth of the witness intimidation statute, Judge, does cover family members of a witness.
Okay.
So I'm not taking issue with that, but it just goes through every single one of these. It doesn't rise to the level of threats or fighting words, Your Honor.
Okay.
It's just, and the other huge issue that the Commonwealth ignores and just wants to look the other way and go after somebody out of their own self-interest, and we'll get to that later, but is this notion that political hyperbole is somehow off the table. So I'm going to rewind a little bit, and that's the Watts case. Goes back to 1969, Your Honor, when a guy who was speaking about the draft, and he said that if they put a rifle in my hands, the first person I'm going to get in my sights is the president, LBJ, Lyndon Baines Johnson. And he was prosecuted under the federal threat statute. And the Supreme Court, they laid it out very clearly. This is called political hyperbole. The context, the distance, the First Amendment aspects of it, it's political hyperbole. It's not really going to happen. It's something that a First Amendment protected speaker says to underline their point, to underscore the force, the rhetorical force of what they're saying. So that principle, Your Honor, is sort of the foundation for a lot of the case law that we cite in the brief, and that, it's
So words to the effect of, I'm going to destroy someone's life, or I'm not going to let them lead a comfortable life.
right.
That's what your argument is, that
Exactly.
even under that case law, which is obviously
Control.
different, but yeah.
Controlling, Your Honor.
That's,
I think the word you're looking for.
yeah, well, that might be your word, but I say
It's the Supreme Court, and that's another issue we want to talk about, judges. The Commonwealth of Massachusetts just forges ahead with this ridiculous statute, this witness intimidation statute. If that statute was passed in 1775, every single one of those legislators would have been pulled out of the State House and tarred and feathered on Boston Common. That statute is ridiculous, Your Honor. It talks about inflicting economic harm, inflicting emotional harm. I think someone's going to receive emotional harm if they hear speech that says, "You're a liar, I'm going to sue you." Under the statute, that's a felony in Massachusetts, not in the rest of the world, not in the rest of the country anyway, not under the Federal Bill of Rights in the First Amendment, but apparently in Massachusetts in Norfolk County, it is.
Okay, let me turn to Mr. Cosgrove. I think you've answered my question.
Thank you.
Let me turn to Mr. Cosgrove. Mr. Cosgrove, maybe, so some of these counts, I mean, there's obviously a lot of counts. There's 16 of them. But going to count 8, which involved a member of the state police, where he's walking out of the courthouse here and allegedly the defendant directs the attention of certain people towards him. And then they chant and they call him names. Does that rise to the level of intimidation of a witness?
I think that's probably the one closest to the line, Your Honor,
Okay.
candidly. But if you look at the testimony and if you view the video, you'll see that he's pursued down the street, he's shouted, he's approached by people accompanying Mr. Kearney with cards that they're waving and so forth. And I certainly think he could have legitimately feared for his safety. The fact that he's a rather robust gentleman and that there are other police officers around might mitigate that fear, but I don't think it was totally unfounded.
Okay, well, but some of my other questions, that just, as we get into these specific indictments, as to the indictments that are at the end of the 14, 15, and 16, that talk about the conspiracy with the person who evidently worked for the police department to get license plates and puts them out there. What's your theory on how that amounts to intimidation of the witness?
A conspiracy to intimidate a witness?
Yeah,
Which is a little different, as Your Honor knows, from the actual intimidation.
yeah.
There was testimony that this person had done this sort of thing for Mr. Kearney before, that she was familiar with his online activities, and that she knew that what was likely going to happen when she turned over this license plate was that it was going to be used to dox the witness. So I think that's the essential theory. And there was also a suggestion, as I recall it, that she herself had some interaction with Mr. Kearney in the past in connection with a niece or something like that, and didn't want to get on his bad side. And I would suggest there was a reason that she didn't want to get on his bad side.
Okay. As to some of the counts that go into the motorcade, where it goes to different people's houses with a motorcade of followers, the actions of Mr. Kearney, are you suggesting that he's acting as an individual or he's acting in some sort of joint venture?
Well, I think the evidence would certainly support joint venture. Essentially, there was evidence that Mr. Kearney planned this motorcade, that he broadcast what the location, the gathering point was going to be, that he showed up with a bullhorn to address the crowd, that he had his cameraman, or perhaps it was he himself with his phone to film the events for a later broadcast. That these people proceeded at his direction to the various locations. Only the first location was announced in advance. So they got there by following him. And when he got there, he got out of the car, and statements varied somewhat from location to location, but harangued the occupants of the house as to...
So let me ask you about count 2. So count 2 talks about intimidation of a witness, 25 to 30 people. Mr. Kearney with a bullhorn telling a witness to tell the truth. How is that not free speech?
Well,
So what involves me?
It's the one that involves what?
Ms. Name, I'm sure.
Well, I don't want to sound like Bill Clinton. It depends on what the meaning of is.
All right.
But
I mean,
in the context of Mr. Kearney saying, tell the truth, I think the witness would clearly understand that what he's instructing the witness is tell my version of the truth.
okay. All right.
In other words, don't change your testimony or don't testify.
Okay. And then,
Wow, that's a reach. It's a huge stretch. See, because the one thing that we know that we have an advantage of here is that trial already took place. All these people testified. All these people testified as exactly how they wanted to testify. Nobody changed anything. They said exactly what they were going to say. They said exactly what they wanted to say. I haven't heard of anybody being injured. I haven't heard of anybody being threatened physically. You know, I mean, when you have kind of the end result where the trial in question actually has happened, and we know that all of these people testified, none of them decided, hey, geez, I'm afraid of Turtleboy and what he's doing. I'm not going to testify. They all testified.
Right.
They-
So that goes the fear factor. But also, I just think that was pure speculation. Tell the truth means I'm demanding you to lie,
Right, it was a huge stretch.
to say my truth, which is a lie.
It's a huge stretch. And he's not answering the question because the judge's question was very pointed. You know, Aiden with the bullhorn screaming, tell the truth. You know, like that's, and the judge asked, well, how is that a violation of
Yeah, I know. I
how-
was I was watching.
all right. I mean, it's crazy.
how about releasing the phone numbers to the public? In your view, does that cross the line, taking the phone number of an officer or of a private citizen and putting that out on his website? Is that
411
something that you think
used
is
to do that.
protected speech?
Phone book.
Obviously, Mr. Bray.
Phone book.
But from your point of view, does that
Remember the
amount
phone
to
book?
intimidation of a witness?
I think there's a distinction between your ordinary, if there is such an ordinary thing as putting somebody's phone number on a website and doing it to a witness in a criminal case with the intent to intimidate that witness. And I think this also relates to a comment that Mr. Bradel made from the defense perspective. The court is to look at this with a very limited lens. Just look at what Mr. Kearney did. Don't look at what else happened. The fact that Mr. Kearney said, throw a rock or show up for an exhibit or, and that's a hypothetical, or show
I was
up
going
for
to
an
say
event,
that happened.
or here's the phone number, go ahead and call. Well, he's not responsible if what results from that are a ton of annoying phone calls, obscene phone calls, et cetera. But I would suggest that that's the intent, clearly, that the grand jury could find in posting that. And that's the practical result of what's being posted. And the intent further is to harass and intimidate the witness.
Okay. Anything that you want to say that you haven't said already, Mr. Cosgrove, in support of your position? I know I started off by asking questions, but if you have anything that you want to direct my attention to,
Sure.
or you think is important, I'm happy to listen, and I'd offer Mr. Bradel the same opportunity. I've read everything that both of you have submitted. Well, let me start with Mr. Cosgrove, and I'll give you Mr. Chairman.
I'd just say a couple of things. First, I heard Mr. Bradel say there was no evidence of this and there was no evidence of that. And with due respect to my brother, I think he's making a layman's mistake in his characterization of evidence. When a witness testifies that I was watching a YouTube presentation and I heard Mr. Kearney urge people to order pizzas and not pay for them, that's evidence. Now, grand jurors can believe it or disbelieve it. Defendant can contest it in court if that same evidence is offered in court. But the fact is, it's evidence of what happened. So I don't think the statement that there is no evidence is accurate. I think in a broader sense, Your Honor, the difference between Mr. Bradle's position on behalf of Mr. Kearney in the Commonwealth is that when you ask, where is the line?
Yeah.
Mr. Bradle's position is essentially there's no line. The Commonwealth's position is that whatever might be the case, there's two lines of cases. There's the line that Mr. Bradle is relying on here. And he suggests that to be consistent with those cases, which talk about imminent harm and which talk about
True threats.
threats being made to the person's face and threats of bodily injury and so forth, that this statute must be unconstitutional and that it is to be construed consistent with these civil cases that he cites. And both of the cases that he mentioned are civil cases.
Which has a lower burden, buddy.
The Commonwealth's position is that whatever the position towards the general public, and I alluded to that earlier, the courts have said that restrictions are possible when there are reasonable limitations as to time, place, and means. And we see that in a number of ways in cases that have been approved by the courts. Cases that have recently had an approval of Judge Cannoni's order with respect to picketing in the Karen Reed case. That wasn't held as an unconstitutional violation. We have decisions in 209A orders where judges order, and I'd cite the court to the case that I didn't mention in my brief, Commonwealth versus Butler. What happened in that case, I think it's fairly well known. Your Honor may be familiar with it. Young woman on the day of her birthday went to her door and found some flowers that were anonymously delivered. I think we'd agree that if you send somebody some flowers on her birthday, that communicates typically a message. Hopefully the message it communicates is happy birthday. Unfortunately for Mr. Butler, about 3 months earlier, the court had entered a 209A order, no contact directly
That's
or
different.
indirectly.
That's different. That's what you're saying.
They
You got-
traced the
get
flowers
remedy.
back to Mr. Butler, was prosecuted, found guilty, the conviction was upheld. That sort of thing happens on 209A orders all the time, which ostensibly
As they should.
you could look at on their face and say, oh, this infringes on my right of association. This infringes on my right to travel. This infringes on my right to make witty satirical statements. Nevertheless,
But Mr. Kearney is a satirist. I mean, in essence, a lot of this is satire.
well, I don't mean to be flip, but so what?
Okay. No, I mean, that's fine.
I don't think there's a special rule for satirists if the so-called satire is made with intent to intimidate.
Witness. Okay, that makes sense. Yeah, I see your argument.
I'll stop at this
That's
point.
fine. I'll give Mr. Bradle, I'll give you just a minute. You've made your argument pretty well, but anything else you want to say?
There are some things, Your Honor. I just invite your attention to pages 9 and 10 of my brief, Judge, where the standard of how this speech is supposed to be judged is set forth. And just a couple of quotes. Speech on matters of public concern is at the heart of the First Amendment's protection. Speech concerning public affairs is more than self-expression. It is the essence of self-government. Speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. The Commonwealth is arguing the other way around. Give us the benefit of the doubt, Judge Doolin. Hey, evidence can be construed in different ways. evidence needs to be linked to a particular person committing a crime. That's what they're lacking here, Judge. And this Janelle Webb conspiracy to run a license plate business, Your Honor, the Commonwealth indicted Ms. Webb, and then for some reason, and I think I know the reason, thought better of bringing the case to court and never arraigned her, never charged her, never did anything with that indictment, which I've never seen in my time. And I think what happened there was that the government, the state police probably realized that, hey, they run these plates on the sly all the time for boyfriends, girlfriends, et cetera, et cetera. And they don't want in the system a precedent where a police affiliated person, quote unquote, runs a plate and then gets indicted for a felony. And I think that's why that never saw the light of day. So there never was any conspiracy charge lodged against Ms. Webb. It's past the year presumptive speedy trial. So that case is effectively dead, Your Honor. That's an important fact the court ought to know. And also, it's not a crime to run a plate. So there was no criminal object of the conspiracy to run a plate. They just want to change, they want to erase the word conspiracy to run a plate, and let's put something in there, even though there's no evidence of it, let's put something in there that'll fly, like conspiracy to commit witness intimidation. There's no evidence whatsoever that 13B was implicated in any running of a plate. In fact, it's quite the opposite. It couldn't be more newsworthy. The district attorney had just gone on television with a remarkable statement vouching for witnesses in his case, that they were fine, they were on the up and up, and leave them alone.
That, but in terms of, so you're under indictments 14, 15, and 16. Your argument is that there's insufficient evidence for those to actually be a crime.
There's no criminal object. And even in the grand jury, Sergeant Tully admits, and he says it's not a crime, it's an administrative violation. He says words to that effect. You'll see it. And he does refer to that, and it's not a crime. That's why they couldn't say conspiracy to run a plate, against the rules, because it's not a crime. That's why they switch it to conspiracy to intimidate a witness. It's not intimidating to prove the exact opposite of what the district attorney said publicly.
I wish they were talking a little more about investigation.
And do know the state police and are visiting them at their home. So it couldn't be more newsworthy, Your Honor. And that's what was behind running the plate, was not to intimidate anybody, but to shine the light of day on corruption. Okay. So that's that. And Judge, another thing about, this First Amendment issue, and whether it's a jury question or a judge question, this is a judge question. You're not the first trial judge that, even in my practice, that has dealt with this. And I put this in my materials. You have Judge Walsh and Stoughton.
Yeah, there were two judges, right?
Right, and so Judge Walsh actually did two things, Your Honor. He did Mr. Schiffer, who's here in the courtroom today, and I appreciate it. My other client, Mr. Schiffer, is the guy that put rubber ducks all around Canton with political statements about the Reed case. And remarkably, the Canton Police Department did a 37-page investigation that was, if they applied that much work to the Reed case, those folks wouldn't even be here anymore either. But they did a 37-page investigation into Mr. Schiffer putting rubber ducks all around Canton. And that's the Judge Walsh opinion, and you'll see it in there, denied on First Amendment grounds. It's not witness intimidation. Denied on, and arguably.
But there's a difference between that and saying we're going to make the life miserable, isn't there?
Well, Judge, that's O'Brien v. Borowski. That's foreclosed by O'Brien. Fear of being sued, fear of being yelled at, fear of being embarrassed. Doesn't cut it.
Yeah, no, take your time.
I wish that they were pointing out, first of all, you should be pointing out that the cases the Commonwealth just cited were violations of orders of protections, of restraining orders. So that's why you can do something as simple as send a flower, and it's a violation. I mean, we see that every day. Hi.
Well, you're violating a court order.
Right. I love you. Yeah, I'm sick of you telling me I love you, and you have been ordered not to say words to me, no matter if they are nice or not. So, I mean, that was ridiculous.
And like you said, I mean, as far as the Commonwealth poo-pooing the fact that he's citing cases that are relating to civil actions, like you said, the courts came down the way that they did, and that's a much lower burden.
No, like the mens rea is completely different.
Completely
So,
different, but it's a lower burden as well.
right. All of it. All of it. You know, I don't, this guy, he barely wants to even bring this case.
He looks like he wants to take a nap, bro.
I mean, he's like,
So Judge, with respect to these rubber ducks, you know, it's the exact same kind of thing that Mr. Kearney is accused of doing, and it's thrown out on First Amendment grounds. It's Colin did it. It's, you know, statements about the case. It's the same kind of thing. And, you know, they went after him. And that's what happens when these kinds of bad statutes get used for ulterior motives by self-interested police and prosecutors.
Thank you so much. It's been a wonderful argument on both parts.
I hate
you.
judges
Both
like this.
groups were very good as well.
Thank you.
I'll take
hate
it under
judges like this.
advisement,
They
and I'll
don't,
have something for you.
they tend to not make hard
Thank you.
decisions.
All right, thank you.
Your Honor.
Next scene, please. Oh, yeah. Let me just, can I talk to the lawyers at side for a minute?
While they're doing that, the other thing I wish he would have said there about the judge kept bringing this up, I'll make your life difficult. It's not going to be easy. Well, no, when people are confronting you about your lies, when we're investigating you, that's not making your life easy by lawful means.
Right.
He
I
should have
mean-
argued that because the judge brought it up on 3 occasions. How, well,
Yeah,
what
I
about,
mean, if Kearney believes that they're lying and he's trying to let them know that we know that you're lying and you're still going to intend to go into court under oath and lie, we got our eyes on you. You know,
Right,
I mean, it's putting pressure.
but all he said
It's
was,
not intimidation, but that it's trying to force somebody to tell the truth on the stand, at least from Kearney's perspective.
right,
That's not intimidating a witness.
but the words are, life's not going to be, you know, your life's going to be difficult. I'm going to make your life difficult, or I'm not going to let you lead an easy life. Your life's going to be destroyed. Something like that. That is not meaning your physical life is going to be destroyed, but you're going to be in, we are in even just the investigation part of you. We're watching to, you know, see if you're hiding evidence, who you're meeting with.
Right.
or-
We're on to you. We're like, we're
Right.
watching you like a hawk,
Right.
you know, and it's like,
I didn't hear anything about,
this is all civil shit. If the McCabe's or the Alberts, they want to sue, they sue. That's what they do. The problem for them in doing that is that the discovery in civil cases, I mean, their lawyers better tell them exactly what they're signing up for, because it's not just depositions. It's also what you can request.
yeah, but
and
all these civil cases, they're citing civil cases where they're saying, no, these don't hold up. They're not true threats.
But what I'm saying is that, you know, even though they're the proper venue for this is civil court, not criminal court. Like
Right. They'd
think-
be opening themselves up to a
I
lot of
mean, you're like, people don't understand that civil shit,
sue for defamation. The truth is a defense. So I get to look for evidence of the truth.
all of it in discovery.
And,
And
you know, I know a lot of people are like, oh, I really like this judge, but I'm just going to tell you, when you have a judge who's really goes out of his way to be like nice to both sides, they don't like to make hard decisions. They just
Right.
don't. So it's like, you know, it's very hard to get them to, you know, like pull the trigger on something.
It's true.
So you end up with some sort of, some stuff gets tossed, some stuff stays kind of thing.
That's a really astute observation and totally true. I mean, I've been in front of judges that just refuse, sweetest guys in the world, but never ever made a call, like never made a ruling. Like it was like, you guys should be able to work this out.
Right.
You know, like what? No, we need
Ugh.
you. We need you to be a judge and make a decision.
Lay
here.
down a line here. Give us
Yeah,
a line.
I get this. I get the same sense. I hope, because none of these should stand, in my opinion.
I mean, we didn't go through all of them, but it doesn't seem to me like any of what has been put forth that we've reviewed that was mentioned in court,
all the same
nothing-
type of shit.
nothing comes close to it. You cannot hold him responsible. The guy gives an example, like if Kearney said to people, go throw rocks at their windows, and then they throw rocks at the window. That is, yeah, that's inciting criminal conduct. You're asking them to break the law, to
Or if
go
he says
damage.
something like, you go in there and lie, I'm going to beat your ass when you get out of court that day. That's a different thing. That's a completely different thing.
Right.
It-
If you're putting them in actual fear of
Right.
physical-
Exactly. Of a physical battery. So, I mean, none of this reaches that. And I think if you read the case law, you begin to understand. And in particular, the Baptist church case with the former Marine who they're picketing his funeral, like, as distasteful as you may find it, it's protected. It's protected speech. I mean, to me, Borowski does create like a very bright line rule in terms of what can be applied and what can't. And just, I think that the bigger issue here is that these cases never get brought. That's probably why. I mean, if you have to resort to civil cases, that's because there's a real dearth, a real shortage of precedent in criminal cases for cases that have been brought under the statute, especially pertaining to free speech.
It's like that. There was that one time when we were in Philadelphia and your car got towed and you had been drinking and you were like going at the cop and you're like, all right, you're going to get yours. And he's like, are you threatening me? You're like, yeah, with calling your calling your supervisor or reporting you, like not with beating you up.
Right. Getting you in trouble.
Right. I'm going to get you in trouble.
Ratting on you. So this is another charge.
This morning I was informed that there was an incident last night. Apparently the defendant and a friend were at CF McCarthy's, which is a bar in Canton. It's next door to D&E Pizza, which is owned by
which is world renowned for their mediocre chicken parms, just so you know.
Witnesses in this case, and his son, who is also a witness in this case, and I should say they're witnesses in the Karen Reed case, works there, and they are both victims listed within the indictments that are before your honor. At the end of the evening, the son closed up at D&E Pizza and went home. There is a video camera, possibly more than one, but one in particular in the window of D&E Pizza. And what it recorded was that Mr. Kearney left CF McCarthy's next door and in the company of a friend, or shortly joined by a friend, walked up, either noticed or had previously noticed the video camera, and walked up to the window quite close, pressed his face up against the window almost, and then stepped back for a moment or two. Spent a couple of minutes just staring there.
Wow, that sounds
and then went into a 2-minute diatribe.
Okay.
Saying hello to the witness. What have you done? I wish he was alive today. Why did you do that, Chris? He's talking to Chris Albert, the witness. I just want to know. And he goes on to say, and I have to paraphrase from here, Your Honor, because I didn't
is
get
this
it
a
all
violation
down in
of
the brief
bond or
time
something? He's no
that I
contact
viewed
with
it.
the
No.
witnesses? Oh.
But I know you didn't do it. Colin did it.
Colin.
And then he goes on essentially to ask why he is covering up for his son, assures him that he's not trying to frighten him. He just wants to know. Just wants to know. Now,
Okay. This is a new charge?
At that point, he walked and went away, leaving
Yes.
Mr. Albert to find that the
So we
next
have to have to
morning when he
dismiss as
reviewed
well,
his
Your
video. Now, we can talk about how many legal angels dance on the head of a pin here, Your Honor. I think I could do Mr. Bradle's argument for him. It's just speech.
It is.
Nothing's meant by it.
That's true.
It's protected.
It's true.
I doubt I've saved him the trouble, but I've tried. At this point, I don't think it's an issue whether technically it meets the standards of intimidating witness.
It doesn't.
I
Doesn't
think
matter.
certainly the attempt, at least in the colloquial sense, was to harass and intimidate.
Now the
We
colloquial
always
sense
talk
matters.
about these in isolation, Your Honor, but there is a drumbeat every week of verbal attack after verbal attack on the witnesses and the officers in this case. So at this point, I am going to ask the court to set bail on Mr. Kearney. He's been released on his personal recognizance. And I am also going to ask the court to set conditions. And those conditions will be no contact, direct or indirect, or through third parties. And I mean no contact in the broadest possible way
Wow, so he's not
with
allowed to
any of
talk
the
about them?
witnesses or officers testified for the Commonwealth in the Reed case or any of the alleged victims in this case. And I am going to ask that Mr. Kearney, as a condition of his release, be prohibited from approaching anywhere within
500 feet?
100 yards of the
100
victim's
yards.
residence
Oh.
or within 100 yards of a victim's place of work.
Okay, thank you. Mr.
Thank you very much, Judge. Judge, this is not how incursions of someone's liberty are done in Superior Court or in any court that I know of in the Commonwealth of Massachusetts. I don't have a shred of paper. I don't have a shred of documentation. I don't have anything on this issue.
You want to continue?
No, I want you to deny it on its face, but if not,
Yes,
I mean, you gotta
certainly.
look at it.
Yes,
You
absolutely.
want to come back tomorrow?
what?
I don't think I can come back tomorrow, Your Honor, but the government needs to, the government should be sent out to go get their ducks in a row, no pun intended. And
Maybe we
Then
could
if
borrow
they have-
Mr. Kearney's.
if they have an issue, then they should come back for it. But you don't say, hey, I heard this thing happened and
Why
I
don't
want
I
to.
do this? Why don't I do this? I'll give you 24 hours, Mr. Bradley. You absolutely have a right to review the video and have a right to see any reports that were written.
See?
I'll see you
Won't
both
draw a
back
line.
there at 2 o'clock tomorrow.
Habitual,
Does
not
that
line
work, man?
stepper.
I was gonna suggest noon.
How about news tomorrow? Does that work?
That's fine, Your Honor, and I don't mean to prolong this unduly, but I just want to say I became aware of this incident that happened last night at 10 o'clock this morning.
That's fine.
So
And that's great, but the government should do some investigation and, give me a chance to say
Yeah,
something.
we'll address it tomorrow at noon. In the meantime, Mr. Kearney, just stand up, stay away from that pizza place, okay? What was the name of it?
I'm sorry, Your Honor. It's
Right next to the
D&E
damn
Pizza.
drinking hole.
Just stay away from that, and then we'll address it tomorrow, okay? All right.
So, the matter is continued to March 6th at noon.
All right, so
Mr.
what
Kearney,
happened
you are
today?
ordered to stay away from D&E Pizza. Do you assent to this condition, sir?
Yes.
And you're hereby
What?
notified if you're charged with a crime during the period of your release, your bail in this matter may be
Stay away
revoked in
what?
accordance with Mass General Law, Chapter
It's only
276.
till tomorrow, I guess.
Okay. Thank you all.
So
There
that's
you
it.
go. That just shows you right then and there what that judge just did. He's like, all right, I'm just going to kind of give you what you want and give you what you want. So I'm going to actually order him to stay away. I'm not even sure if it's 100 yards from the pizza place, but also you got to let him view that video and let's come back tomorrow and address it. I mean, that's what you get. We get a judge who is afraid to make a
Yeah,
rule.
I didn't see the hearing today. They did come back today. I know that I don't think that I don't know that they filed a motion to revoke yet. I mean, they might try to. I
He
know that
didn't
they
vi-
did-
that's not a law. He didn't break the law. How are
I,
they violating him?
I don't know. Because he picked up a new charge. They charged him right
Did they
there.
actually?
Yes.
No,
she
I
just
think.
charged him at the end of the hearing. Right
Wait,
here. Like right at the very end. Here, I'll throw it back up.
Wow. It's not a crime.
Matters continue to March
Yeah,
6th
look.
at noon. Mr. Kearney, you are ordered to stay away from D&E Pizza. Do you assent to this condition, sir?
Yes.
And you're hereby notified if you're charged with a crime during the period of your release, your
If.
matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58.
Okay,
Thank you.
thank you all.
Thank you, Your Honor.
He's not charged with any crime. The hell's
No,
everyone
today,
talking about?
today he was. So they-
Today he was?
yes, it was back up today. And they also put all those bond conditions in place. So he's got it.
my.
So here's what I'm going to say about this, and then I got to go because I got a 6 o'clock live with Sean Martin of Potentially Criminal. Hope you all come. We're going to be sending to that. Make sure that you like, share, and subscribe as well. If you're new to the channel, welcome. Spread the word. We're a pretty good channel. We're going to give you some real shit here. Going to give you just facts. Obviously through the lens of defense attorneys. I mean, that's what we are. So, but the overarching theme here is that what they're doing is when you have the very same cops that are involved with Reed and who have a vested interest, the same attorneys on the government side that have a vested interest in getting a conviction in Karen Reed's case, and they're weaponizing this statute in order to shut down the loudest
Naysayers,
voice.
investigators,
Right,
whatever.
by far the loudest voice. It should scare the shit out of everybody.
It should.
It should
should.
absolutely terrify everybody. I
And
don't
it
care
doesn't
where
matter.
you
It doesn't
live.
matter what you think or feel about any of the people involved. The mere
You
fact
can
that the
hate Turtleboy.
government,
You can hate the way he speaks. You can hate his vulgar language, all that shit. None of that matters. Because what we're talking about here is them using criminal statutes to shut people down from speaking publicly.
trample all over our constitutional rights. It's an outrage.
It
It's
really
an
is.
outrage in every sense of the word. But I'm going to say this, and it's not a but, actually. It's a just on the other hand, onto something different. It's very normal to have stay away orders. That's why I thought maybe there was a stay away order, and that was the crime, that you have orders that you cannot have any communication with the any victims or witnesses in your own case. Like that can be very typical. And I wonder.
I think they brought those conditions of bond specifically. That was what they're in the entire
That's
point
what I
of
thought it
charging
was.
Right. The entire time, like the entire point of adding that charge was to get those conditions of bond met.
Why would
Which
did
they
a
did.
judge deny them initially, or they didn't ask? Do we know?
Like I don't know. I don't know. But I mean, obviously there was no, like, he would have had bond violations all over the place.
Mr. Nice Guy judge just does whatever the state asks. Just does
So,
what the state asks.
I mean, obviously we're going to keep following this. It's of the utmost importance to us as Americans. And, you know, in terms of what this judge is going to do, if he follows the law, I mean, he's got to see, like, look, I may not like your approach, but it's protected speech. It just is. Like, because I've seen, like, you know, the one thing that they did with Colin, you know, Colin, we watched that video that Colin put out, whether he was talking shit, like the Advantage Boys or whatever. And he's like, bang, bang. And then and then Aiden did something with bang, bang. And they're trying to make it sound like he's threatening him with shooting him. And I'm like, what? It's like he's mimicking what the kid was doing on his own It's like that's the kind of shit that they're trying to turn into a crime here, and it's really, really scary.
And I don't think there's any records in this case that's going to be able to be used against Karen Reed. I can't imagine.
Well, that just came out today. So Hank filed a motion. I'm going to go over it with Sean on our next live. He filed a motion trying to get his Aiden's phone dumps for guilt of consciousness of guilt against Karen Reed. So
what?
Telling you, you'll be there hopefully, but if not, you'll have to tune in. I'm going to go through it.
All right, Afton, that question's going to be answered on the next live. But I just want to thank all of you for your generosity. Afton, Leah, Molly, and Leah again. And
Like,
Cyberchick.
everyone was desperately trying to get me to pronounce his last name correctly.
I just assumed you talked to the guy like you know how to pronounce his name, for God's sakes. And don't
I've always
even say again.
thought it was Kearney.
All right, well,
That's how it's spelled.
I know, but there was like a thing. He's said it publicly on his stuff before about how everybody says his name wrong. So I just assumed you had it right.
Well, they always say it how it's spelled.
Hey, it's that.
I'm a phonetic guy. Like I pronounce
I mean,
things with their
sometimes even
spell.
when I know it, when I'm reading
My
it,
entire life, I said Reading Railroad wrong because it's spelled reading. Like
it is
every,
Reading.
every,
Right.
every time I played Monopoly, it was always Reading Railroad. People are like, "What railroad?" I'm like, "Reading." They're like, "Dude, that's Reading." I'm like, "No, dude. Redding is Reading. Reading is reading." So, but same difference. But yeah, I think I knew it somewhere in the back of my
In the deep
mind.
recesses of your
But I
mind.
always just call him Aiden. Like I rarely ever refer to him as Turtleboy, and I certainly never use his last name. I just call him Aiden, which I know I'm pronouncing right. So, all right, but you guys are amazing. We love you. Thank you. Make sure you share, like, and subscribe. If you're in Replay Crew, throw a comment in there. It helps get us in the algo. We're getting close. We're getting close to 40K. It's exciting. We're excited about that. And if you're new, sub. We love having new people in here, and we got a great chat. I argue it's the best chat in the land. So
Thanks
all right,
again, all of you guys, for all my birthday wishes and gifts and donations. You're all so generous. We love you.
because without y'all, I'm just an old man
Sitting around talking to his wife.